SJC-11751, Commonwealth versus Gardner.
Mr. Reardon, good morning.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Thomas Gardner. With me today is my partner, Deborah Reardon. There are several issues before the court today, Your Honor. The first issue has to do with the flaw in the jury instruction. When the jury was instructed on the deliberate premeditation theory, the judge instructed on the elements, including the element
Can I ask you, it's not, you're certainly not foreclosed from arguing that the model jury instructions are erroneous, but where did Judge Nickerson deviate from the 2013 model jury instructions in the step-downs that you raised?
There was one variation when he was talking about when he was defining manslaughter, and he gave the model instruction, but then he ad-libbed. So what this means is that manslaughter has the same elements as murder 2, except that the Commonwealth hasn't proven the absence of mitigating circumstances. So it's a slight variation, but it comports, I would say, with the substance of the model instruction, just a different way of saying it.
Right, thank you.
So I read your brief and I read it again, and I still don't understand where the jury was misled.
Okay.
Can you point to specific things that Judge Nickerson said which are inaccurate or misleading?
Okay. The first one is this. The judge instructed on the deliberate premeditation theory and talked about how if the Commonwealth had failed to prove the absence of mitigating circumstances but had proven everything else, it would be manslaughter. Then the judge went on to discuss the elements of the extreme atrocity and cruelty theory and the felony murder theory. Then went on to discuss murder 2 and described that as having the same elements as extreme atrocity and cruelty minus the element of extreme atrocity and cruelty. In failing to tell the jury...
I'm sorry, I'm going to stop you there.
Yes.
So far, that's right, isn't it?
That is true. The problem is that in discussing the deliberate premeditation theory, the judge talked about how a possibility lesser included offense is manslaughter, did not mention murder 2, and then when describing murder 2, described it as having the same elements as extreme atrocity and cruelty. There was no mention in discussing of murder 2 that it was also a lesser included offense of the deliberate premeditation theory. It was just described in context of how it's a lesser of the extreme atrocity and cruelty theory.
But that's verbatim from the model instruction?
Yes.
Okay.
Yes.
And aren't there provisions in Judge Nickerson's instructions where he does all the step-downs and says, if you find this, you find murder 1, go to murder 2, and then manslaughter? By my count, he did it twice. By my count, he did the step-downs twice in these instructions.
He did, but my point is that the instructions, the model instructions, talk about how manslaughter, when discussing deliberate premeditation, mentions how manslaughter is a possible lesser included offense. It doesn't mention murder 2. But then, when discussing murder 2, it describes it solely in context as a lesser of the extreme atrocity and cruelty theory. So nowhere in the discussion of deliberate premeditation or murder 2 is there mention that murder 2 is a lesser also of the deliberate premeditation theory.
But of course you understand the question we're going to ask, which was the jury didn't come back guilty on a theory of deliberate premeditation. And if you look at second-degree murder, what second-degree murder is the three prongs are the same as first-degree murder with extreme atrocity and cruelty, and the only difference between second-degree murder and extreme atrocity and cruelty is that there's no finding of extreme atrocity and cruelty. So therefore, as it don't matter as it relates to your client, I'm not sure I see the error either, but if as it relates to your client, how could there be any prejudice? Because the jury found first-degree murder, extreme atrocity and cruelty, so they had to have found one of the intents necessary for murder.
I
Do you
think
understand my question?
I do. I think there's actually two variations of that. My first answer to this is this. The court has had a variety of cases where a defendant was convicted on the greater offense and there was a flaw on the lesser included offenses of that charge. And the Commonwealth has said, well, it doesn't matter that there were flaws on the lesser included offenses because they were convicted of the greater. And the court has repeatedly said, no, that the defendant is entitled to a correct charge on the lesser included offenses, and the jury is entitled to find on the lesser included offenses. And even though in this particular case, the jury found for the greater offense, it's reversible error because the jury should have been instructed on the lesser included offenses. And so I would say that same argument applies to here, that even though he was convicted on the extreme atrocity and cruelty theory, the Commonwealth's theory that it was greatly pushing at trial was the deliberate premeditation theory. The Commonwealth devoted almost the entire closing argument to the deliberate premeditation theory and just mentioned in passing at the very end the extreme atrocity and cruelty theory. And so, especially where that was the Commonwealth's theory, the jury should have been properly instructed on the lesser included offenses of that theory. So that would be my first response. I think your other, embedded in that, your question, was also that, in essence, I think that the jury was properly instructed on murder two because, yeah. So as to that issue, the problem is that as the judge was describing, as I originally cited, the elements of deliberate premeditation, the judge told the jury about how manslaughter was a lesser included offense, but didn't similarly say that murder two was a lesser included offense. And when describing murder two, never mentioned deliberate premeditation as being a greater offense. It was strictly in context of the extreme atrocity and cruelty. So it would be a leap for the jury, in light of the judge's explicit instructions about murder two being a lesser of the extreme atrocity and cruelty, for them to somehow put together that it's also a lesser included of the deliberate premeditation theory.
But the problem you have is that deliberate premeditation requires intent to kill, and murder two permits a conviction for intent to kill, intent to commit grievous bodily harm, or the third prong. And the judge explained that. I mean, it's not so clean to say it's a lesser included because second degree contains elements which premeditation does not.
Yes, but nevertheless, murder two is a lesser included offense of the deliberate premeditation theory.
Well, I mean, are you saying the error was that the judge did not use the term lesser included offense? Because that's a legal term bound to create some confusion in the context of murder.
I think what the judge should have done is, right after saying that murder two has the same elements as extreme atrocity and cruelty, minus this one element, the judge should have also said, murder two is also a lesser included offense of the deliberate premeditation theory. Even though I've described murder two in the context of being a lesser included of the extreme atrocity and cruelty theory, please don't think it's only a lesser of that one theory. It's also a lesser of the deliberate premeditation.
Okay, I mean, the only problem, well, it is true that if you take the elements of murder two and the Commonwealth fails to prove the absence of mitigating circumstances, then you have the lesser included of manslaughter. Yes. It is not true that if you have deliberate premeditated first-degree murder and you take away the deliberate premeditation, that you necessarily have second-degree or voluntary manslaughter, because you do have an affirmative obligation to prove that if it's not the first prong, that it was the second or third prong. So it seems like it's confusing for a jury to be using the lesser included because you're adding two prongs which are not present in premeditation.
I hear what you're saying, Your Honor, but on the other hand, nevertheless, murder two is still a lesser included of deliberate premeditation, and the jury wasn't told that.
But if it's going to be confusing to a jury, and if the jury were properly instructed as to what the elements are of each of the other crimes, why would Why should we require a judge to give an instruction which probably is more likely to confuse a jury than to enlighten it?
Well, because the instruction as given right here just says that murder 2 is a lesser included of the extreme atrocity and cruelty. That is how it was defined.
So are you suggesting then that as the jury's going through the verdict slips or the charge in the order that they are instructed to do so, that theoretically, if they got past deliberate premeditation, they would then consider second-degree murder and say, well, maybe we met all those elements, and then they shouldn't keep going to extreme atrocity and cruelty? Is that what you're arguing?
No.
That they would have stopped, or they would have found second degree under deliberate premeditation and not reached extreme atrocity and cruelty?
I'm saying that the jury should have been instructed on everything. And if, in their wisdom, they've decided that the Commonwealth was pushing the deliberate premeditation theory, and we find a lesser included offense of that theory, and they decide to stop there, then that's their option. They could also alternatively find the extreme atrocity and cruelty theory, but they weren't really given the option in this case. They were only told that murder 2 was a lesser included of the extreme atrocity and cruelty theory.
I'm sorry, I'm having such a hard time, Mr. Ridden, understanding, what the prejudice is in the circumstance, because if the jury first looks at extreme atrocity and cruelty, and they don't find that, say, that intent to kill has been proven beyond a reasonable doubt, or deliberate premeditation, either one of those, then they don't go to second degree. They have to go to the extreme atrocity and cruelty next, and they just don't drop down to second degree yet. So since they had to go to the extreme atrocity and cruelty next, and since second degree is a lesser included there, I really want to understand where you say the prejudice is when you think about that's the flow of the instruction.
I think the point is that in this particular case, the Commonwealth was really focusing on the deliberate premeditation. And it's entirely possible that had they been properly instructed, they would have focused in on the theory the Commonwealth was pushing and decided that he was guilty of a lesser included offense of that. For the same reason that the court has held that on a singular offense, where there's a failure to charge of the lesser included offenses, that's error, notwithstanding they were convicted of the greater. I think the court in those cases envisions maybe it's a compromised verdict, and the jury didn't want to find not guilty, so they found guilty of the greater offense.
Can I take a stab at what your argument is then, because I'm really having a hard time understanding it. Are you saying that since the trial was really about deliberate premeditation, that if the jury had the option of a lesser included of second degree on deliberate premeditation, since that was the trial was about, they might have chosen that rather than gotten into discussion about extreme atrocity and cruelty, which wasn't really how the case was tried?
Exactly.
Is that what your argument
Yes,
is?
yes, yes. On the button, yes,
Thank you.
yes. Unless there's no further questions about that, I'll move on to the second argument. The second argument would be the improper cross-examination and closing argument of the defendant about his failure to go to the police pre-arrest. And there was a long series of cross-examination questions about that, and the prosecutor noted it in closing argument, in particular, that the defendant, when he saw the police, or the police saw him in the rest stop in Connecticut, that he did not go up to the police officers and say, hey, I've got something to tell you. And they made another comment about it later on in the closing argument. And the law is replete with references that it's improper to do that because the defendant does not have any obligation to go to the police and report any version of events or an exculpatory version of events. The Commonwealth responds to this by saying, well, yeah, but the defendant did actually end up making a statement. The problem is that we're talking here about pre-arrest statements, and the post-arrest statements are entirely different. The case law that I've cited is clear that the Commonwealth cannot make any reference to the defendant's pre-arrest silence. And there's nothing in those cases that says the holding would be different had the defendant made a post-arrest statement. The Commonwealth cites two Appeals Court 128 decisions, which it says supports its position. But in both those cases, the statements by the defendant were pre-arrest. And so the court held that it was okay for the Commonwealth to elicit variations on the pre-arrest statements. So those cases don't support the Commonwealth. What we have here is the defendant's pre-arrest silence, and there's no authority that the Commonwealth can make comment on that because he made a post-arrest statement.
Okay, imagine you're right. The standard then would be harmless beyond a reasonable doubt?
Yes.
And would the fact that he did make a statement to the police post-arrest bear on that analysis?
I don't think so, no. No, I mean, it doesn't make it right, and it doesn't, no, I don't know.
So what would be the forbidden inference of the jury with regard to the reference to pre-arrest silence? That if he had not killed him, and if it were truly self-defense, he would have gone forward? Is that?
Yes, the improper influence the inference being that this was all the defendant's defense was a fabrication, because if it was true, he would have gone to the police with it ahead of time. The third argument, Your Honor, before you is the improper closing argument by the prosecutor about the defendant supposedly striking the decedent after he went unconscious. There were two primary sources of information about what transpired. The first was the medical examiner, who talked about the decedent's injuries, but she was unable to elucidate as to which, if any one of them, was the fatal blow, and whether or not the decedent was unconscious during any one of those blows. And the only real evidence about what happened was the defendant himself. And he testified that he repeatedly hit the decedent, but all of those blows were while the decedent was conscious. He explicitly denied hitting the decedent while the decedent was unconscious.
Given the gravity of the injuries, how is that harmful?
How is it harmful? It's because the theory that the defendant was convicted on was extreme atrocity and cruelty.
We have 4 skull fractures and multiple lacerations with a hammer, and there's some issue about whether that's extreme atrocity or cruelty?
The prosecutor seemed to think it was because he pushed that on the jury and saying that the decedent was unconscious at the time. Apparently, the prosecutor thought it would be an influence on the jury.
And can't the prosecutor infer from the autopsy report and the severity and number of the blows that some share of them were after the victim was unconscious?
I don't think that's a fair inference at all. If the prosecutor wanted to make an argument just saying that the number and severity of the blows demonstrates extreme atrocity and cruelty, well, that'd be fair game. But that isn't what happened here. They cited to the allegation that the victim was gratuitously struck after he was unconscious as supporting an extreme atrocity and cruelty theory.
But it goes also to the issue of self-defense. But you have, I think there were 5 blows that the examiner said could be sufficient by itself to cause death. Am I correct? Or there were multiple blows that they said if those alone would have been sufficient.
I don't think the ME testified. I think that he said he couldn't say which one was fatal or not fatal, or I don't actually think they said that any one of them could have been sufficient. I may be wrong on that.
Okay. But I guess my question is, when you have that number of blows with that severity of blows, is it not a fair inference that some share of them were done after the victim was unconscious? Because there were apparently, 20 or something in that ballpark, or 14 or 15?
I don't think it was 20. It was less than that. But regardless, I don't.
The number of blows with the hammer.
I don't recall the exact number.
Okay. But I mean, I guess my question is, if you have that many blows with a hammer, is it a reasonable inference that some share of them were done after the defendant was unconscious, given the reasonable inference that some share of them less than the total would have rendered him unconscious.
No, I don't think that's a fair inference.
Okay?
Thank you, Your Honor.
Thank you. Mr. Nadeau?
Thank you, Your Honor. Good morning. May it please the court, Stephen Nadeau on behalf of the Commonwealth. Just to deal briefly with the first issue, in response to counsel's argument, even if the deliberate premeditation were the main thrust of the Commonwealth's case, clearly the jury was not persuaded of that, for they did not convict him under that theory. They convicted him of extreme atrocity and cruelty. And there's no allegation that there was anything improper about those instructions, and I would suggest that Commonwealth versus Brown certainly stands for the proposition that even if there had been some error in the premeditation instructions, they were not prejudicial because, again, he was not convicted on that theory. He was convicted of an entirely separate theory. Moving on to the second issue of the cross-examination, our position is that the particular configuration of facts in this case made it appropriate for the prosecutor to question the defendant about his failure to notify police. Critically in this case, as opposed to many others, the defendant did not remain silent before or after his arrest. He, in fact, affirmatively chose to lie. His first direct lie to the police was when they encountered him on the street in Connecticut, and they asked him if he was in fact Thomas Gardner. At that point, he lied to them, said, "No, I'm a construction worker. I've been working in that building over there." And when they pulled up the picture, of course, he confirmed that, yes, I am Thomas Gardner. And so he was placed under arrest at that point. When he's under arrest, he makes the decision to lie again to the police with this fabrication, which he admits when he testifies was a fabrication, that he had been on his way to Pennsylvania with the deceased, and that when he saw the police, he led them on the high-speed chase out of the rest area and into Westport, Connecticut, that he had left the victim behind.
I get all that, in that certainly it would have been fair game for the prosecutor to argue that he lied when he was confronted, and they can infer all sorts of things about consciousness of guilt from that. But I don't see how that opens the door to him saying, if you say now that it was self-defense, why didn't you immediately go to the police?
I would suggest that it was fair because not only did the defendant admit during testimony that he lied to the police on those two occasions, but he acknowledged that his efforts to deceive or conceal the crime began in the moments after he killed Mr. Duarte. He obviously hid the body, cleaned up the blood, but he sent a text to Mr. Duarte's phone apparently to convey the false impression that he believed Mr. Duarte was still alive. And given that backdrop, the prosecutor should have been able to probe at what point did this cover-up include the plan to lie to police when you encountered them.
I don't respectfully, I don't get it. We generally don't allow the argument to say, if you were so darn innocent, you would have gone to the police, and you didn't do that, therefore we can infer that because you didn't go to the police, you're not as innocent as you say you are. Why is it different here because he testified in a way that you argue was deceptive? I don't get why the forbidden inference is somehow permissible in these circumstances.
And so I would suggest that it's not just about the lying to the police and then questioning about why he didn't go to them at a certain point, because this isn't just about his silence prior to encountering them. In fact, when he first saw police in Connecticut, he led them on a high
I know,
speed.
there's no question that, prosecutor could have argued all that stuff. The question is not whether they could have argued all of the consciousness of guilt after he was confronted in Connecticut. My question is, how does that let in to say, why didn't you immediately go to the police as opposed to going to Connecticut?
Again, our position is just that the pattern of misconduct, which he admitted to or not misconduct, but pattern deception and concealment, which he admitted to during his testimony, allowed the prosecution to probe at which point during that concealment did he decide that lying was going to be a part of that process. But even if the court does view that as an improper questioning or improper reference to his failure or his credibility or his consciousness of guilt, there's certainly in this case much more dramatic evidence affecting his credibility, affecting or showing his consciousness of guilt.
Do you get to prejudice? If we could just stay with the Chief's question just for a moment more before you get to whether there's prejudice, if there was an error.
I'm sorry, Your Honor?
Just before you get to whether there was prejudice, if there was an error with that cross-examination. There's a difference between where you spoke to the police, you spoke to them on this occasion, on that occasion, you told them A, B, C, and D, but you didn't tell them E. That's different than a cross-examination. Oh, you never went to the police and told them about E, did you? There's a big difference between those two. Because one of them suggests that you had an obligation, despite your right not to, against self-incrimination, and for that not to be an argument for the jury, you have a right not to have gone to the police.
Correct, but I think the implication here is not necessarily why didn't you go to the police, but perhaps, so you admit that you lied to the police, why did you lie to them, and when did that idea enter?
I'm sorry, the cross-examination was essentially, you were attacked, this is self-defense, and if a true person who was attacked and had a legitimate self-defense would have run and screamed to the police. That was the cross-examination, right?
I think that's certainly an interpretation of it, but I think the facts here allow for other inferences drawn from that line of questioning. Again, this is a case that dramatically departs from any mere failure to report or mere silence before or after arrest.
Okay, well, now turn to the issue of prejudice.
Yes. So even if the questioning were improper and commented improperly on his credibility or his consciousness of guilt, as I mentioned, there was much more dramatic, attention-grabbing evidence. Certainly the high-speed chase, the concealment of the body under the stairs, running to Connecticut when he's encountered by police in Connecticut, this high-speed chase on the highway, onto the local roads where he ran over a police officer's foot, where he struck a Bentley and continued going forth. And then the fact that when he is finally stopped by police on the street, he lies about his identity. When that's exposed, he's arrested, and then he lies to the police in this extended interview where he's kind of joking around with them, and then he testifies by his own admission that in both of those instances he lied, and that he deceptively sent that text message to Mr. Duarte's phone, even though he obviously knew he was already deceased. This was not something that the Commonwealth belabored particularly in its cross-examination, and certainly not in its closing argument.
Well, it mentioned it in closing.
Again, the context that came up in the closing, I would disagree that it was a comment on the silence. The two times that a reference of that kind appears in the closing is a reference to the encounter with the police at the rest stop. And certainly it's sort of phrased as he didn't go to the police with his story, but what happened in the case and in the argument is not he didn't tell the police his story, he remained silent. What he did was take off speeding at 100 miles an hour on the highway and going on this dangerous chase through Westport, Connecticut. And the second part, I believe, was the post-arrest, when it wasn't that he remained silent, it's that he lied to them. So again, these were not comments on silence, these were comments on his affirmative actions, which would be fair comment in closing. And again, all of those aspects are overwhelming evidence of his lack of credibility, of his consciousness of guilt, and again would be much more dramatic or scintillating for a jury. It's hard to believe that the outcome here was influenced by, yes, he did all that crazy stuff, but really we're concerned about the fact that he didn't go to the police or that he remained silent.
Of course, invites the issue as to why, given the overwhelming nature of the evidence, the prosecutor would risking defeat when victory was in his or her grasp by doing this.
Correct, and perhaps those questions were better left unasked, but again, I think this was sort of a unusual configuration of facts, and the prosecutor may have been.
But is it that unusual? I mean, it's not unusual for someone to beat somebody and then claim self-defense, and then when they get arrested, say something else. I mean, that's not that unusual set of facts in a murder case.
No, certainly that piece of it is not unusual, but again, we do have, as I mentioned, the dramatic car chase, the hiding out for hours in this post office that's under construction.
The problem, this is the problem I'm having, is that somebody could get into a fight with somebody in a home, and the person ends up dead. And as they're sitting there calibrating whether or not under the law this is self-defense, which they might not even completely understand, they decide to take off for Connecticut. And then when they say to the police, they see the police, they say, it's not me, and then they send a fake text message to the victim to sort of say, oh, I thought he was alive. Those are all sort of things that someone desperate who just killed somebody might do, even if it might later on fit into a doctrine of self-defense.
Right, and I think that...
And that's the problem, I think. That's the problem I'm having.
And I think that is certainly appropriate for argument. Defense counsel argued that at trial, but as far as the question of whether that was prejudicial, given the nature of the evidence here, again, it's exceedingly unlikely that that line of questioning could have influenced the result. Granted, maybe there is an explanation for why he went on that high-speed and dangerous.
Maybe the explanation is, and this is where the damage comes with this type of cross-examination, if you're so innocent, why don't you go to the police, is that maybe he did all of those things because he's got a dead body back at the house and he's inculpated in it. So he takes off and he does all these things. He's got consciousness of guilt that he killed somebody. But that doesn't allow you to say, well, if it was really self-defense under the law, why don't you go tell the police?
Again, so that inference would have been improper if it had been argued straight that way, but essentially the way the evidence came in and the way the argument went in so even assuming there was improper comment on his failure to go to the police, it was in sort of a litany of facts. He failed to go to the police. He ran to Connecticut. When he was found in Connecticut, he went on this high-speed chase. He ran over a police officer's foot. He crashed into a Bentley. He lost control in a dog park. He hid in the rafters of this building for 4 hours. He lied to the police when he encountered them on the street. He lied to them during a post-arrest interview. Again, for the question of prejudice, exceedingly unlikely that first fact would have been the deciding factor or even an influential factor in a case like this to a panel of jurors that does not deal routinely with murder cases. It's unlikely that would be the single thing that drew their focus and influenced the result here. If there are no other questions on that issue, I'd move on to the issue of the closing. And as to that issue, Your Honor, the medical examiner, as I recall, testified, I think that there were 19 apparent injuries, 13 lacerations of which were clearly distinct and went all the way to the bone, and that there were 4 clearly distinct skull fractures. And the medical examiner could not say with any certainty which, if any of those injuries caused the deceased to lose consciousness or which ultimately killed him, but did testify that it could have been any one of them. So even one of those wounds could have knocked him unconscious, could have killed him. And it's from the defendant's own testimony that at some point Mr. Duarte lost consciousness during the attack. And granted, the defendant does go on to testify that he woke up and he came at me in sort of the scene out of a horror movie. He's not quite dead yet, so we had to finish the job. But the prosecutor is, just like the jury, is not required to accept fully the testimony of any particular witness or reject fully the testimony of any particular witness. They can accept some and reject other parts, and I think that's what the prosecutor was doing here. It does seem, in retrospect, a fair argument grounded in the record, and I would suggest there was no error. And again, even if there were error, it was not prejudicial in this case.
All right, thank you.
Thank you, Your Honor.